During your confirmation hearing, you said your focus would be on deporting immigrants who have been convicted of crimes and those who have received removal orders, but that is not what you have been doing. Instead, you have been deporting children with cancer, children who are U.S. citizens, a gay makeup artist who committed no crime and didn't even enter the country illegally. You have been sloppy. Your department has been sloppy, and instead of focusing on real criminals, you have allowed innocent children to be deported while you fly around the country playing dress up for the cameras. Instead of enforcing the laws, you have repeatedly broken them. You need to change course immediately.
This may look like a heated exchange between a lawmaker and a cabinet official, but it's actually a stress test of how much unchecked power the executive branch can exercise before the law intervenes. What's really being tested here is whether enforcement agencies are still bound by due process or whether operational speed has replaced constitutional restraint. This raises broader questions about how easily fundamental protections can be sidelined when political pressure meets bureaucratic authority. In this video, we'll break down how this hearing exposes the widening gap between stated policy and real-world execution, and why that gap matters for democratic accountability.
You're back.
Gentleman yields. I now recognize Mr. Magaziner for 5 minutes.
Madam Secretary, on April 24th, a woman in Louisiana was deported along with her 7-year-old daughter and 4-year-old son, both of whom were U.S. citizens. The 4-year-old son had stage 4 cancer. Now, you just stated under oath that the mother consented to having her U.S. citizen children removed. But I have spoken with the attorney for that U.S. citizen child with stage 4 cancer. She has also made numerous statements to the press in which she stated unequivocally that at no time did the mother consent to her U.S. citizen children being removed. What evidence do you have to support your claim that she did consent?
Congressman, we followed the same policies and procedures.
What evidence do you have?
And we
what
have
evidence do you have?
We have
that
documentation
she?
that
what documentation do you have that mother consented?
We'll get that to you, sir. I don't have it with me.
Please
today.
do. I understand
That
it's
mother
hard to keep them all
consented
straight
to
because you've
take her
deported
child with
multiple
her.
U.S. citizen children, but I'm asking specifically about the 4-year-old with cancer who was deported on April 25th. For the record, that family was also not given access to legal counsel before they were deported, even though their lawyer was in the same building at the time. I'm holding in my hands here a document called ICE Directive 11064, Interests of Non-Citizen Parents and Legal Guardians of Minor Children. This is the policy for how ICE agents should handle situations like this. It states unequivocally that parents and legal guardians should have the ability to make alternative care arrangements for minor children prior to their arrest or detention, and that ICE must afford parents the opportunity to consult with legal counsel. So, do the ICE agents working on this case who deported this 4-year-old with cancer of their own volition fail to follow ICE policies, or were they directed to by your office or anyone else in DHS leadership?
Sir, this mother chose to keep her child with her.
You have not produced any evidence to say so, but I'm asking again, have you directed DHS officers to ignore this
It's
policy?
very different than the previous administration. The previous administration
on March 15th, reclaiming my time, on March 15th, your
change.
department sent 3 airplanes to El Salvador. Those planes carried approximately 261 individuals who were imprisoned upon arrival. Did you personally review and approve the names of those 261 individuals before they were sent?
Sir, we have deported and sent home
did you review the names of those
And
individuals?
we have individuals that have
Why
the
won't you answer the
responsibility
question?
within the Department of
Are you
Homeland
aware
Security.
of whether those 261 individuals were given the opportunity to speak with a lawyer or appear before a judge before they were put on those planes? Yes or no?
Sir, every single individual followed the exact same process.
They were not all given the opportunity to appear before a judge or speak with a lawyer. On April 7th, the Supreme Court ruled that detainees must have an opportunity to have a hearing before they are deported. Are you familiar with the April 7th Supreme Court ruling? Can you assure us that in the future you will abide by that Supreme Court ruling to provide detainees with a hearing before they are deported?
Following all judges' orders, yes, sir.
I have a photograph here of André Hernandez Romero, a gay makeup artist from Venezuela. He fled Venezuela fearing gang violence because of his opposition to the Maduro dictatorship and his sexual orientation. He presented himself at a port of entry and requested asylum. His claim was found to be credible, and he was placed in detention to await a full hearing. But he never received a full hearing because you put him on one of those planes to El Salvador, where he still is today. Listen to me. He had no criminal record in the United States or in any other country. He did not even enter the country illegally. He presented at a port of entry. He tried to do it the legal way. And to this date, the only evidence your department has presented to justify his imprisonment is that he had 2 tattoos, one that said mom and one that said dad. Do you have any other evidence to present for why this individual should be locked up in El Salvador?
Sir, every case is used
you have
the
any-
same protocols and the same processes and inputs.
Do you have any
that
evidence
that
other than the
law enforcement
tattoos that say
officers
mom
using
or dad
criminal
for why
cases.
this
So
individual
it's not
should be
just
locked
on
up?
tattoos. It's who they're affiliated with, their communication.
You have not
who they're
presented
spending
any
time
other
with,
evidence,
criminal
nor has your
activities.
department.
The cases
Reclaiming
go
my time,
exactly the
during
same
your
as it is
confirmation
with
hearing,
other
you said your focus would be on deporting immigrants who have been convicted of crimes and those who have received removal orders. But that is not what you have been doing. Instead, you have been deporting children with cancer, children who are U.S. citizens, a gay makeup artist who committed no crime and didn't even enter the country illegally. You have been sloppy. Your department has been sloppy, and instead of focusing on real criminals, you have allowed innocent children to be deported while you fly around the country playing dress up for the cameras. Instead of enforcing the laws, you have repeatedly broken them. You need to change course immediately before more innocent people are hurt on your watch.
Gentleman's time has expired. I now recognize...
What we just witnessed in that chamber was not a routine exchange of policy talking points. It was a collision between a member of Congress demanding evidence and a cabinet secretary unable or unwilling to produce it. Seth Magaziner pressed Kristi Noem on a single searing case from late April, a Louisiana family removed from the country alongside two American-born minors, one of them 4 years old and in the middle of a life-threatening medical fight. Under oath, the secretary claimed the parent had agreed. Magaziner, holding ICE's own Directive 11064 in his hands, read back the rules that say families must be allowed to consult counsel and arrange care. Then he asked the simplest, most devastating question in government: what proof do you have? And in that moment, there was none. That silence matters. It matters because in a system built on law, procedure is the thin line between authority and arbitrary power. When a department cannot produce the paperwork that justifies a decision affecting the lives of American citizens, it is no longer operating as a neutral administrator. It is operating on assertion. And assertion, when backed by the force of the state, becomes something far more dangerous than a mistake. It becomes a precedent. Magaziner's line of questioning exposed something deeper than a single file missing from a folder. He revealed a pattern of governance that treats human beings as case numbers, as transport loads, as entries on a manifest. When the secretary was asked whether the family had been allowed to speak with counsel, even though their lawyer was in the same building, the answer was not a clear yes or no. It was a deflection. When she was asked whether ICE agents ignored their own directive or were ordered to do so by leadership, the response drifted into talking points about keeping families together. But keeping a family together means nothing if the process strips away the rights of those within it. And then the hearing widened. Magaziner shifted from one family to an entire fleet of flights. On March 15th, 3 planes carried roughly 261 people to El Salvador. Were their names personally reviewed? Did they have access to counsel? Did they stand before a judge? The answers came back in fragments. They followed the same process. Not all were given a chance to see a judge or a lawyer. In the cold language of bureaucracy, the same process can hide a multitude of injustices. It can mean that everyone was treated equally poorly. The Supreme Court spoke on April 7th. Detainees must have the opportunity for a hearing before removal. That ruling was not ambiguous. It was not advisory. It was the highest court in the land drawing a bright line. When Magaziner asked if the department would obey it going forward, the secretary said yes. But a promise made after the fact does not undo what was done before. In a constitutional republic, compliance is not optional, and it is not retroactive. It is immediate. Then came the story of a Venezuelan makeup artist who arrived at a lawful port of entry, sought asylum, and was deemed credible. No criminal history, no illegal crossing, just a person waiting for a full hearing that never came. Instead, he was placed on one of those planes. The only evidence offered to justify his confinement abroad? 2 tattoos that read Mom and Dad. When Magaziner asked for anything more, there was nothing concrete. Vague references to affiliations and communications floated in the air, unsupported by documents or sworn statements. This is what happens when enforcement drifts away from law and toward expediency. The state begins to rely on intuition instead of evidence, on suspicion instead of due process. And once that happens, anyone can be caught in the net. Citizens, asylum seekers, families, artists. It no longer matters who you are or how you arrived. It only matters that a bureaucratic machine has decided to move you. Magaziner reminded the secretary of her own words from her confirmation hearing. She had said the focus would be on those convicted of crimes and those with removal orders. Yet the record presented today showed something very different. American-born minors removed with their parent, a lawful asylum applicant sent away without a full hearing, hundreds placed on planes without seeing a judge. This is not targeted enforcement. This is scattershot governance. And when leaders defend scattershot governance with talking points instead of documents, trust erodes. Trust in institutions is not lost because people are emotional or misinformed. It is lost when officials cannot explain with clarity and evidence why their actions were lawful. It is lost when policies written on paper are ignored in practice. It is lost when the people most affected are the least heard. There was also a moral dimension to this exchange that cannot be ignored. A 4-year-old American citizen fighting a grave illness is not a political prop. A makeup artist fleeing a dictatorship is not a threat by default. These are human lives intersecting with the machinery of the state. When that machinery grinds forward without checking its own rules, it does not just violate statutes. It violates the basic idea that government exists to serve and protect the people under its jurisdiction. This hearing was not about one secretary or one department. It was about whether power in America is still constrained by law. Magaziner was not asking for sympathy. He was asking for documentation. He was not demanding emotion. He was demanding accountability. And the inability to provide it should concern every viewer, regardless of party or ideology, because today it is one family in Louisiana. Tomorrow it could be someone else. The strength of a republic is measured not by how it treats the powerful, but by how it treats the most vulnerable when no one is watching. In that room, cameras were rolling, and still the answers fell short. That should tell us something. As the gavel fell and Magaziner's time expired, what lingered was not a policy debate, but a question hanging in the air. Who is guarding the guardians? Who ensures that when the government acts in our name, it does so within the bounds of law and conscience? The answer cannot be silence. It cannot be vague assurances. It must be vigilance. It must be citizens who demand transparency and leaders who provide it. This is why these hearings matter. This is why independent media matters. This is why you are watching. The story you just heard is not finished. It is still being written in courtrooms, in agencies, and in the lives of real people. The only way it ends with justice is if it is watched, questioned, and challenged. Stay with us. Support our work to expose the truth. And subscribe to Liberty Report USA.